Good morning and happy Sunday to everybody. And of course, a happy Father's Day to all of you fathers out there. And that's why some people thought that maybe the show may not even go on today because of Father's Day. But no, here we are hard at work every day. As long as you will come to join us, we will be here to talk about whatever needs to be talking about. So, yes, it is Father's Day today. And I appreciate all the good wishes that we've got in the chat. Thank you very much. I got to say, when I was talking to my wife about this, she says, every day is Father's Day, and therefore there's nothing special about today more than any other day. And I got to say that I agree with her. After working a full day, you come home and the kids run up to you and give you big hugs, and there's no greater feeling. I mean, that's every day. When you get that feeling every day coming home as a father, that is just the best. And in fact, especially when you have special days like today, Sunday, or holidays, you get to spend some extra time with the family and the kids. So like, for example, today, I'm going to come and go watch my kids play some baseball and, sit in the fans and cheer them on. So every day, I mean, like that, what greater pleasure is there in the world? So it's just a true pleasure, and it's enjoying life to its fullest. And there is a special day on the calendar for it, but I got to tell you that I enjoy every single day as Father's Day, as my wife noted. So she's a smart woman. Anyway, so without any further ado, we got a lot to talk about today. Obviously, we got to talk about the entire last week, some of that testimony, even though I was kind of out of town, as some of you know. And then we also have the closing arguments that I definitely want to get Brother Solomon's opinion on. So without any further ado, let's bring on Brother Solomon, Brother Counsel's brother, national trial lawyer. Brother Solomon, happy Father's Day to you.
Happy Father's Day to you as well. That was a very nice intro that you just made. And I just want to tell all your viewers, in case they don't know this, that Martin's kids are insanely good at baseball, like ridiculously good, like 13 and 14 years old, and they can play with adults easily. It's actually kind of humiliating and humbling watching them play, because sometimes I'm stuck playing with them. But I digress.
Yeah, well, thank you. They also not bad on the on the hockey either, So hockey.
They're ridiculous when it comes to hockey. And happy Father's Day to everybody watching as well.
Okay, well, great. Solomon, we got a lot.
One second. And I'm sorry. One more thing before we start. I'm trying new headphones today, so if it's difficult to hear, somebody please leave something in the comments, letting me know, and maybe I'll just take them out if there's any echoes or anything like that.
Yeah, I'll let you know. So far, it sounds great from here. So that sounds good. I just wanted to put up this one. We got already a post here. Make it make sense. Happy Father's Day to the Radner brothers, and mainly Papa Radner. Would have been nice to get Papa Radner on the show today. I actually went over yesterday to talk to him, but he was not available. So we were not able to get him, but we will eventually get him on the show. Don't worry about that. So,
do you know where he was yesterday?
Yes, I know. He was at your house. I know.
He was at my house for lunch. Yeah, okay.
Yes, I know. I found that out once I got there. So you beat me to it. But anyway, we'll get him on the show eventually. We'll get him on the show. So the first, we got to talk about the closing. I played a bunch of different clips of the closing in my last video. I don't think I'm going to play any clips for you, but I want to talk to you about it. I know you've seen it because I forced you to see it. I want to talk to you about it. But first, before even talking about that, I want to talk about something else. And that is that we both have been in trials where sometimes the judge allows note-taking, sometimes the judge does not allow note-taking. And when the judge, in my experience, when the judge allows you to take note, allows the jurors to take notes, she doesn't say you cannot take notes during opening and closing. And in this trial, Judge Canoni said, since the opening statements and closing arguments are not evidence, then she does not allow the jury to take notes. Tell us your thoughts about that.
I think it was a strange ruling. Frankly, I've never seen that in all the trials that I've done. When the judge allows notes, the judge allows notes. I is sitting here trying to recall. I don't recall a single time when a judge instructed a jury that they can take notes during testimony and during evidence, but not during openings and closings. And that's just, I guess it could be something that each judge does, and I just have never had a judge tell a jury in front of me that they can't take notes during openings and closings. But it's certainly something that I've never seen. And also, I don't think it's really sensible to do that, because during the openings and closings is really when we lay out what the case is all about. Very often, especially when there's a lot of exhibits in a case, I'll tell the jury, as you all may remember, there was this particular testimony, and that exhibit was exhibit, 23B, page 47. You'll see in the middle, there's a paragraph there. So if you want to jot that down, you can. I've noticed sometimes jurors are very, very good about taking notes, and I want to give them as much information as possible so that when they're deliberating, they have it readily available. Again, especially if there are a lot of exhibits. So I don't agree with the ruling, but I mean, as her rulings go in this case, she's made so many asinine, ridiculous rulings that this one doesn't even scratch the surface. And I'd let this one slide.
It's funny because actually, Alan Jackson in his closing referenced the exhibit that talk about the text messages that Michael Proctor sent, the ones that zero chance she skates. And this is a couple hours after the investigation started. So we already know where Michael Proctor was going with this investigation. And when he laid out those exhibits and those text messages, he said to the jury, okay, that's exhibit, I think it was 209. Remember that, exhibit 209, and they were not able to write it down. And another reason why I thought, and as I was talking about this and thinking about this, why, even though I understand Judge Cannoni's point that there's no, the lawyer's statements are not evidence, and she's instructed the jury in that in the first initial instructions and the closing instructions, but if we are talking about the evidence, like you said, so if there is something that we're arguing and it reminds the juror, oh yeah, I wanted to think about that or look up that piece of evidence, let me just make a note about it. And now if they're not able to take notes, they're going to forget about it. So yeah, I thought again, it was a silly ruling. And if you're going to allow notes, then at least allow them to take notes the entire trial.
It really made no sense. Based on that ruling, why have openings and closings at all? If it's not evidence. And if there is a point for them, allow them to take notes.
Exactly. Okay, Deanna Bellino, happy Father's Day to Brother Counsel and Brother Counsel's brother, also known as Brother Solomon. I think we're going to go with that. And all the dads in the chat. All right. Okay, so Solomon, you saw the closing arguments. So tell us your 30,000-foot view, and then I'm going to point out certain things that I liked about Jackson, but I want to kind of open it up for you just to give your initial thoughts about both closing arguments.
Initial thoughts. Jackson did an absolutely outstanding job. 10 out of 10, knocked it out of the park, focused on the evidence, focused on the absurdity of the allegations that are being made, did a very, very good job, a very impressive job of presenting his arguments and relying on the evidence. And obviously that's very important, relying on the evidence. Hank Brennan, his closing, frankly, was terrible. It was a bunch of conclusory statements. It did not rely on evidence. It relied on video clips where she's being interviewed. And after a 7-week or 8-week trial, however long it was, with $500,000 spent by the Commonwealth on experts on other things, and dozens of witnesses testifying, when the best thing you got is a couple of clips that can be distorted and misconstrued by Karen Reed, that really shows how weak your case is. The fact that, and I'm sure we'll get into more of the evidence, but the fact that the last thing the jury heard was the defense experts, and the Commonwealth, obviously, they could have called plenty of people in rebuttal. And I'm shocked that they didn't. But at the same time, I'm also kind of not shocked because they wouldn't have gotten anywhere. It would have just been more obliteration by the defense against the prosecution. So I think that this verdict should have already been in, frankly. And I know that juries do different things when they get the case. Sometimes they take an initial vote. Sometimes they say, okay, before we vote, we should take a look at the evidence. If they do that, they're going to be deliberating for quite some time. But every jury that I've ever spoken to after I've received a verdict, I always ask them what happened in the jury room. And they always tell me that the first thing they do is take an initial vote. And I'd be very surprised if when they take the initial vote, whenever they do it, they're not all unanimous on the murder charges. The only possible conviction here is drunk driving, which would be a truly pathetic showing by the prosecutor.
We'll get to that. We'll get to that soon. But first, I really want to just, we're going to talk about the verdict form in a minute. But first, I want to talk about the closing argument. Something that I noticed this time around, which I think that Alan Jackson focused on this time a little bit more than last time. And it could be that they were listening to guys like me, that and our reactions to the first closing argument, which was, and we think that this was just in general, their entire approach this time I felt was much more different. The first time it felt like the approach was that they're going to try to prove this conspiracy. And that's kind of what, and they kind of made their job harder. This time it felt like they're just concentrating on reasonable doubt. They want to show the jury that that's really all this case is about, whether the Commonwealth has actually proven their case beyond a reasonable doubt. And Jackson spent a lot of time this time, definitely the beginning of his closing arguments. Remember this, Solomon. And I know that this is something that you do. This is why this is something that I've learned from you, that you really have to explain to the jury just incredibly how high that burden is, reasonable doubt, and that they took an oath, and that even if they think that it's very likely that this person actually committed the crime, it's still not enough. And if they want to follow their oath, they have to still write not guilty on the verdict form. I've seen you do it a number of times, and it's something that stuck out to me this time, that Alan Jackson focused on, that to try to tell the jury that in Massachusetts, the language is to a moral certainty, which is the highest amount of certainty in human affairs. So that's the language that they kind of use. And something that he stressed, and I think that was a very bit of a different feeling this time around, that we don't have to prove anything. And he said that. We don't have to prove anything to you. It's all about reasonable doubt, whether the Commonwealth actually proved their case. So is that something that that stuck out to you and you thought that he did a good job with?
I thought he did an excellent job with that, and I also think that's a very important point to make in your closing. I think that when you make that closing, you have to really drive that point home, because that's what the case ultimately is all about. And it's easy after such a long trial with so many witnesses and so much testimony to kind of get lost in the weeds. And that's why ultimately it always comes back to, what's the jury charge? I always base my closing arguments on ultimately, what is the jury charge? What are the instructions? What are the elements that I have to prove or that I have to disprove, depending on which side of the V I'm on? And it's something that I think he did an excellent job on. It's something that really needs to be driven home during closings, that if there's reasonable doubt, there's reasonable doubt. Let's take a look at it. Here's the elements that they messed up on. And if there's, for example, 4 elements of a charge and they've proven 3 of them, then don't focus on those 3. In fact, you can even tell the jury they've proven these 3. But here's why, based on your oath and based on the law, your verdict has to be not guilty. Let's look at this element. And I'll put it up on a slide. I'll say you have to be convinced beyond a reasonable doubt that this element has been satisfied. But if we take a look at the evidence here, you don't get there. You just don't. So yes, that's a point that absolutely has to be driven home.
Let's also remember that what he did was, Alan Jackson, that he had a slide. We couldn't really see this all clearly when you were watching it on the live stream, but you did see some pieces of it. And that's where he had this slide where he had a bunch of little cards on the slide which showed reasonable doubt. And then when he was going through his closing, it would be okay. Then like that card would blow up and he would talk about that. And then that card would go back. And there's all these flashcards essentially of reasonable doubt. Also, something that I think also was important, that I know that I've learned this kind of from you and other lawyers that I've implemented in my own trial practice, is where you have to tell the jury what their job is very clearly. Why are they here? And you just argue the case, they send them back, and they don't really know exactly what their job is. They just listen to an hour of jury instructions by the jury when no one's listening to, by the judge when no one's listening to. So I've learned, you tell the jury, listen, this is what your job is. Your job is to determine whether the Commonwealth proved their case beyond a reasonable doubt. That is what your job is. And now that you understand what your job is, now I'm going to explain to you why there is reasonable doubt. So, something else that I thought he stressed on. Another thing that I saw from him, and tell me if this stuck out to you, because I know you like to do this also. There's a lot of similar patterns that I saw with Alan Jackson, which I see with you a lot. And that is that you use the other attorney's statements and their positions against themselves. So, for example, one of the things that he used was Brennan's own description of the scene at 6 o'clock in the morning, which Brennan said was bedlam. So don't take my word for it. You don't want to trust me because I'm the defense attorney, the high profile defense attorney. Okay. Brennan agreed. He said this himself, that the scene was bedlam in the morning. And still, despite all the chaos and bedlam, Brian Albert was not woken up and didn't come downstairs. And yeah, I mean, that's also just something that I noticed, that he's using Brennan to win his case, essentially.
Right. That was a very smart move. It was a very strong move. And there was also something that he did that you and I have talked about on your show several times, which is, and I saw Jackson do this. I forgot what the point was right now, but one of the points that he made was he practically turned to Hank and said, perhaps Hank will tell you this in his closing. I forgot what the point was about. You're nodding and smiling, so maybe you remember. But
that was my next.
I do. Okay, I do that in virtually every closing. Okay, so what was that point? Remind me.
That was my next point I was going to bring up with you. So there was he did two things. The first thing that he did is that I have 3 questions. He tells the jury, I have 3 questions about this case. Okay. And the jury, you should also have these 3 questions about this case. And unless you have an answer to these 3 questions, your verdict has to be not guilty, right? I mean, that's the obvious inference. And he says, okay, these are my 3 questions. Talking about the sweatshirt. He said, how does 36 abrasions go through 9 holes of the sweatshirt? How do you get 36 abrasions when there's only 9 holes in the sweatshirt? That's question number 1. Question number 2. There's no slices in the hoodie. They're just punctures.
Yeah.
If this was a slice through, then how are there only punctures in the sweatshirt? Number 3, no blood, no skin, no tissue on a single shard of taillight. So those are the 3 questions that I have. So that's, again, he was just putting the ball into Brennan's court. You get up here and explain this to the jury. And guess what? Guess if Brennan addressed those 3 questions?
He didn't.
He didn't.
He just made conclusory statements. Right. And look, I mean, sometimes as a lawyer, you're just beat. We've all been in trials like that, particularly in the world of criminal defense. I've had this in murder cases when the guy's just dead to rights. There's no beating the case. The evidence is too strong. And either the defendant's not willing to plead or the prosecutor's not willing to make an offer. And I've had that happen. So you have nothing to do other than try the case and just hold the prosecutor's feet to the coals and do your job and, fight like hell. It's your job. Your job is zealous representation. If you can't do it, don't do it. But I've had cases like that where there was one case in particular that's kind of that I'm remembering now. It was probably 10 or 12 years ago. It was a murder case. And we were just obliterated. There was nothing going on for us. My client was going to get convicted and she knew it. And they had her cooked. So she got up and she testified. And that was kind of like the Hail Mary. And we saw Hank Brennan throw a lot of Hail Marys this case, but this was our Hail Mary. And I kind of prepared the whole case with her, went through everything, told her what the cross-examination would look like. And then she got up on the stand and she did a pretty decent job in her direct. Then on cross, it looked like the defense in the Karen Reed case taking on some of these experts. It was just, I was just sitting there deer in the headlights watching it happen. There's nothing I can do. Occasionally you can object, but there's not a whole lot you can do when you're just watching your client get categorically destroyed on the witness stand. And I watched that happen. And as a lawyer, then after that, you got to get up and make a closing argument and try to convince the jury that here's all the reasons that she's not guilty. The only win in that case for me is that it took the jury 25 hours to convict her. The co-defendant took them about 40 minutes. But it happens sometimes. And that's kind of the sense I got watching Hank Brennan.
That was
Hank Brennan looked completely
with 2 juries?
That was one of the cases with 2 juries. And I've had multiple cases with 2 juries. In fact, the first trial that I ever tried was 3 juries. It was an armed robbery trial.
I remember one of your trials with 2 juries. But this is something else that it just reminded me of watching these 2 closing arguments. Normally, like what you said, when the prosecutor closes the case, they go through the evidence, they show very clearly how the elements are met and how this person's convicted. And then the defense gets up there and says, well, she didn't tell you about this. What about that? And what about this? And, oh, that's reasonable doubt. And this is reasonable doubt. They don't really go methodically through the evidence. They just kind of try to attack different things that hopefully will stick. I've seen that play out a number of times. And in this case, it's just the opposite. Alan Jackson went through all the evidence, explained why they all show that Karen Reed is innocent. Then Hank Brennan gets up and says, Jennifer McCabe is such a sweet person. She came out to help him. And John O'Keefe was a person who always helped other people. And they're such good people. And there's also some text string data. And don't forget, when I asked him this question, and this is the type of answer that he gave, okay, yeah, you're just pulling out different things that have to do with this case, but you're not walking the jury through the evidence, showing why you win. That's what you have to do. And it's like they switch roles. That's what I noticed.
We call that grasping at straws. Because there is no evidence of guilt. There just isn't. There's absolutely no evidence of guilt. None whatsoever. There was no collision. The car did not hit John. That fact has been proven. And once that fact has, not only is there reasonable doubt as to whether the car hit John, it has been proven, I would argue, beyond a reasonable doubt that the car did not hit him. And if that's the case, the whole case goes away, except for potentially drunk driving, which is, again, just an absolutely pathetic move by the prosecution.
Well, we're going to get to that soon.
Later.
We'll get to that in a minute, but I just want to finish off just a few more points about the closing argument, and that was also where Alan Jackson, again, one of your things that you love to do is when you put it on Brennan, you put it on the prosecutor, and here what he did is he said, remember what happened with that fiasco with the sweater, where Brennan pulled up the sweater and said, look, there's holes in the back of it. And tried to suggest to you that those holes were there, and Dr. Wolf didn't consider it or didn't know about it, and then that actually was false. And Jackson said that, and he said, again, he said Brennan should address this. He may not want to address this, but he should address it with you. And guess if Brennan addressed it with them? No.
The same way he addressed the other points and all the evidence.
And that was, again, another point where, and I think in that situation, I understand the idea of when one lawyer wants to bait the other lawyer and the other lawyer's like, I'm not going to be baited into what this other lawyer says. Here, it's all about your credibility. Your credibility is literally on the line right now. You showed the jury something and created this inference, which is false. And you may have been mistaken about it, but that's what you did. So don't you think that you should correct it with the jury and say, look, there's a lot of evidence in this case. I made a mistake. I mixed up some of the evidence. I thought there was a hole in the back. I'm sorry. There's just so much evidence here. There's 31 days of trial. And I made a mistake, but that doesn't mean that that everything else I did in this case is corrupted or something like that.
I will tell you, I would have done that a little stronger if I would have been the one closing in this case. I would have directly challenged Hank Brennan to address those issues. And those probably would have been my closing points so that it's fresh in the jury's minds. And so that when Hank Brennan gets up to make his closing, those points are kind of lingering in the air like a balloon, and just kind of address them point by point and really focus on it. So you all remember when Mr. Brennan held up that sweatshirt, this sweatshirt right here. You all remember that, right? And I love asking questions during my closings, even though they're not allowed to answer, because it keeps them engaged. And there's nothing better as a lawyer, as a trial attorney, than making a point to a jury and seeing them nod and smile. And there's one case I was trying about 10 years ago where I was kind of showing the jury something, and I asked them a rhetorical question. You all remember this, don't you? And like 3 or 4 jurors said, oh yeah, we do. the judge interrupted me and said, okay, ladies and gentlemen, Mr. Radner is going to be making some points and he's going to be saying them as questions, but don't answer them. And then we go sidebar because the defense attorney objects. This was a civil case. I was plaintiff. And she said that I shouldn't be allowed to do that. And it's improper to ask questions like that of jurors. And I just kind of looked at the judge and I said, Your Honor, you know I'm not doing anything wrong. And he sided with me, and I went back. And the first thing I did was I looked at the jury and I asked them more questions. I said, you all remember that testimony from so-and-so, right? And I see a bunch of nods and smiles, and that ended up being a multi-million-dollar verdict. I know you worked on that case too.
I think Alan Jackson actually did something like that. I think he said, like in his closing arguments, we can all say it together. There was no collision. I think he did something like that. I may be, like that. Yeah, but he did exactly that. Okay. Final point about the closing arguments, and that is, I know we spoke about this in our last video, but I want to hear your take about how he did in the closing argument when he spoke about Kelly Dever and talking about her false memory.
Mm-hmm.
How it was a specific. She remembered it. Nobody coached her to remember it. It was all on her own. She was there they were there for a wildly long time. She remembered how it made her feel. All this detail, all of that. And then she says, oh, it must have been a false memory after she's called up to the commissioner's office. How do you think he dealt with that?
Amazing. It was amazing. He proved that she was lying. And that's what you got to be able to do. So yes, you're talking to one law enforcement agency, you tell them this with specific detail. And then you get up after you talk to the commissioner and they say, do the right thing. We have your back, rookie. And then completely change everything. Oh, that entire thing was a false memory. What, like a dream? That's not how false memories work. I know we addressed this a little bit. And by the way, that episode I was talking to everybody about last time about the false memories, it's brain games. There's a brain game episode about it. And if I find it, I'll send you the actual link to it. But it's really, really incredible the way that false memories can be implanted. But that's not the way it works in the way that Dever claimed it worked. You don't just think that you went to Disneyland when you didn't go. It's that you think somebody was wearing a blue jacket when they were wearing a red jacket, or threw a punch when really they handed somebody a dollar. That's the way that works. So no, I don't think it was convincing at all. I don't think she came across as truthful. And I think that Jackson did a great job demonstrating.
Yeah, that's because after he laid it out, he's like, "What? It's a false memory? What?" So like it was just, I mean, it's just some people say, oh, it's all theater. I mean, part of it is theater. I mean, but you're trying to make a point, and I think the point's well taken. Okay, let's move on because we kind of spoke about a little bit about before, and it came up. Let's talk about the verdict form, because this time around they added a charge to the lesser included. So remember, the first charge is second-degree murder. Just that's it. No lesser included. Second one is involuntary manslaughter as a result of OWI. Okay, and then there's like 7 lesser included this time, and one of them is just plain DUI or OUI or OWI, whatever they call it in Massachusetts, right? It's just plain drunk driving, which, by the way, I'm going to take full credit that the Commonwealth was watching my videos, because I've been saying after the first trial that if they would have just charged her with plain OUI, they would have had a good shot at getting a conviction. So maybe that's why they added it. But what do you think when a jury's getting this form and they're getting second-degree murder, and then they're getting the involuntary manslaughter and leaving the scene, and then they kind of throw in there, oh, and in case you just don't buy any of this, well, maybe we can get an OWI. So number one, what do you think the jury's going to be like thinking about if they're willing to acquit her on everything and then just click that box of OWI? And also, what do you think it reflects on the feelings of the prosecution about their case?
It demonstrates incredible weakness when you're asking the jury, find her guilty of murder. And if not murder, find her guilty of manslaughter. And if not manslaughter, at least, please, don't make us do this all for nothing. Find her guilty of drunk driving. It really comes off as weak. It's kind of a pathetic look. I've had cases where prosecutors have fought me on not giving the jury a.
I'm sorry. Hold on a second. I'm getting some comments from the chat that the defense were the ones that requested OWI. The defense requested it.
Wow.
But the prosecution has to agree, right?
I generally, it's up to the court. If you ask, it's up to the court. I can tell you that generally speaking, somebody has to request it. The other side is allowed to object to it. And then if there's a basis to give it, the judge will give it. But okay, here's if the defense asks for it, I'll tell you why they asked for it. It's very simple why I think why they would ask for it. Very often juries like to split the baby. All right. They like to do something for the other side. I don't know why. That's just the way it is. I've had lots of cases where verdicts literally make no sense, because in order to find somebody not guilty of one charge, you necessarily would have to find them not guilty of the second charge. But I've had cases where the jury will find him guilty of one but not the other. I'll give you the classic example of this. In Michigan, there's a charge called felony firearm. The way felony firearm works is if somebody is convicted of committing a felony, and in the course of that felony, he possesses a firearm, then there's a separate charge for felony firearm, which is committing a felony with a firearm in possession. The way the jury instruction comes to the jury is count one is, let's say, assault with intent to do great bodily harm less than murder, or armed robbery. Let's say armed robbery. So committing an armed robbery with a firearm, and it'll say in the jury instruction that they committed this felony of armed robbery, and it'll give all the elements. Count two is going to be felony firearm. That, number one, in armed robbery was committed by the defendant. That is an essential count. Count two, that the defendant possessed a firearm while committing this felony. I've had juries come back with only felony firearm, which makes no sense. There's no factual way to get there. And if a judge would do it at a bench trial, it's an automatic mistrial. It's reversible error for a judge to do it. Juries, and this is something that the Michigan courts have done, which makes absolutely no sense at all. They say that juries are allowed to compromise. They're allowed to do whatever they want, whatever happens in the jury room. They can come out with whatever verdicts they want, even if it makes no sense at all. You and I know that the exception is if they come back with money for a plaintiff, then obviously courts love to overturn verdicts. But in a criminal court sense, if the jury comes back with a nonsensical verdict, very often it'll be allowed. And it's allowed for whatever reason. So So back to our case here with Karen Reed. It's possible that the defense was thinking there are going to be some jurors here who are going to want to hang Karen Reed, or there are potentially jurors who are going to want to hang Karen Reed. And if that's the case, let's give them something to hang her on. Alternatively, and I wasn't intentionally using the word hang, but let's just say that the jury all agrees not guilty of the three main charges, and there are some jurors who are categorically not going to find her guilty on anything, and there are other jurors who are categorically not going to let her walk. What you can end up with, and I think this would be the most comical verdict of all, would be she's found not guilty of everything, and then the jury is hung on drunk driving. That would crack me up. And
it's funny.
I don't know what the prosecution would do at that point.
Yeah, I mean, it's funny. I really have to think about this. Like, I mean, this is the first time I'm hearing again that the defense added, or they were the ones that requested the OUI, because I mean, I think that that's the easiest conviction, as I've been saying from the beginning. But yeah, I guess it shows some sort of compromise. But if you don't have OWI and they just hang again, I think the defense is going to be happy with them hanging on all three charges, and then saying to the Commonwealth, okay, try the case again if you want. You want all your taxpayers to completely rebel against you. Go ahead, try this case a third time.
But especially if it's only drunk driving.
Right. So if it's only right. So, but if I'm the defense, I don't know. I'm just thinking about this now. Would I want OUI on there just plain so that the jury can say, okay, we'll give her something, a slap on the wrist or something? And then also the other question that I have to Solomon is, like, I'm just thinking myself, if you're the jury and you're finding her not guilty on all these main charges, are you gonna really check that box on the bottom and say, we'll throw this on her? Like, after this woman's been put up facing death in prison, and now we're going to just find her guilty of like jaywalking, like that's what we're going to do as a jury?
I think the majority wouldn't. I think the overwhelming majority of jurors would not do that. I think the overwhelming majority of jurors who would find her not guilty on the main charges would obviously believe that this entire investigation was crooked from the start, and therefore they'd find her not guilty of everything. Again, I think that this could be a strategic move. I could see this being a strategic move by either side. By the prosecutor for saying, at least give us something out of desperation, and the defense to say, okay, if there are jurors who are just categorically not willing to let her walk completely, let them find her guilty of drunk driving, or let them hang on drunk driving. But
yeah, well, tell me, Solomon, you're the civil rights guy. We were talking already before a bunch of shows. We got asked questions about if Karen Reed is acquitted of everything, can she initiate some sort of 18 USC, 1983 type of what's it called? Lawsuit, civil litigation, right? So, so if she's found, let's say, not guilty of everything except just OUI, they find her guilty, let's say, on just OUI. What does that do in terms of her her lawsuit that she may be able to file as a result of the 1983 cause of action?
That's a very good question. Okay, first of all, it's 42 USC 1983.
42, yeah, I'm sorry. 42 USC.
It's all good. So generally, in order to file a lawsuit for false arrest or malicious prosecution based on the Fourth Amendment, you have to win the criminal case completely. There can't be a plea and there can't be a conviction of any sort. For example, let's say the police show up at somebody's house and arrest him, and there's no probable cause to arrest him. Then that person can sue if there was no probable cause for the arrest. If they arrest him and charge him with 25 felonies and he ends up pleading guilty to one of them, or being found guilty of one of them, there was probable cause to place him under arrest. Now, what's interesting about a case like this is that sometimes it's fact specific. And when you have a case like this where obviously the real charge here is drunk driving, vehicular manslaughter, second-degree murder, the case is really not about drunk driving, it's really about murder, then I would certainly hope that a court would allow a due process claim and a Fourth Amendment claim under 1983 to survive. There could be an abusive process claim. I haven't looked this up in this particular circuit. This is going to vary by which federal circuit you're in. But I know that, for example, in the Sixth Circuit, there's no abuse of process claim that's been recognized. It hasn't really been categorically eliminated, but it hasn't quite been recognized. This, to me, would be an abuse of process claim, and it would have to tie in to either a malicious prosecution or a false arrest of some sort. But given the unbelievable violations of her rights here, I think there's really good bases to be able to move forward with claims like this, even if she is found guilty of drunk driving. Further, and this is even more important, there are Brady violations that took place here, because if the police were found to have lied, which I think the evidence supports, and they can prove that in a civil trial, in a federal trial under 1983, that would necessarily implicate Brady, which is a separate violation in and of itself, whether you're guilty or not. You're entitled to evidence under Brady. And in this case, the Brady is the cops just literally, I mean, the allegation would be that they just got up and committed perjury and doctored the evidence and did all kinds of illegal stuff. And had they been forthcoming with the prosecutor and said, hey, by the way, we planted the evidence and we lied about this and we lied about that, and we were conspiring with each other the whole time, then obviously the entire trial wouldn't have lasted 5 minutes. So even if she is found guilty of drunk driving, I think that there's a very strong likelihood that she's going to walk away from this case an exceptionally wealthy woman. But again, right now, her life is on the line. Because if she's found guilty somehow through some insane way by a bunch of jurors who just didn't watch the trial at all, then she can go to prison for a very, very long time.
Yeah. Okay. Well, if she gets out, or if she just if they just get her on OUI, you'll still be willing to take the case.
I'm sure Thomas Jackson has that covered. I'm sorry,
Alan Jackson. All right.
Yeah,
let me get to a few comments here. Trial World says, look the other way. If I show Dr. Wolf holes in a sweatshirt, look the other way. If I plagiarize Jackson's closing, look the other way. And this is something I know that you've also heard about, where Alan Jackson's theme last trial in his closing argument, I don't know if you remember it, was look the other way. And this is Alan Jackson's closing argument. He's like, their whole case is look the other way. And he went through this, that was his whole theme. In this closing, Hank Brennan used that whole concept of the defense just wants you to look the other way. And he used that whole theory. Now, I know you have a very good relationship with one of the top trial lawyers in the country. And I think this is something that you told me about happened once with one of his trials, no? With the Johnson and Johnson?
Give me a little more.
Was it with
I need a little more context.
Was it with Johnson and Johnson where you had where Mark Lanier used a certain a theme about this is CSI, and then in the next trial, the other side tried to use that against it? What does that happen?
I know what you're thinking of. So one of the things that, Mark Lanier, for those who don't know, you can Google him. He is probably the most prominent trial lawyer in the world. He's gotten billions and billions and billions of dollars of verdicts. If I were a defense attorney going up against him, I would just give up and say, how much do you want to settle? I really would. It's almost like there's no point trying the case against him. He wins almost every time. And he does a tremendous amount of research before he tries a case. So there was one case, if I remember the story correctly, I heard this a few years ago. He tried the case in one state where there was one particular TV show that was very popular. And when he presented the case to the jury, he said, this is this case. And I forgot which TV show it was, but this is this show. And all of his slides were geared towards, you're the jury and this is the case. And it's all about that TV show, whether it was CSI or Desperate Housewives or whatever it was. And then the next trial he tried against the same group of lawyers and same defendants was in a different state. And he did his research there, and there was a completely different TV show. And when they presented their case, they presented it like it's this TV show. And then he got up and said, no, the defense has it all wrong. That's not this. And he explained why that's not. He goes, really, it's this. And then his entire theme was that other TV show, something along those lines. I'm not really sure how that connects here, but that's
it's just that, like, it just reminded me, because that's what Hank Brennan did. He used Alan Jackson's theme in the last closing argument.
Okay, but that's the last case, and
right.
Trials, you gotta be able to kind of go with the flow a little better than that. Stay liquid, and I don't think Hank Brennan scored any points in his closing. I really don't. I think his closing was incredibly, incredibly weak.
Jody
But
Arrington.
again, what if you or I were stuck in and said, okay, you have to close. How would you close? I always ask myself this before I close. I always say, if I were the other side, how would I close? What would I say? And then you address those points. You can even say, now the other attorney may get up and tell you whatever. And then you kind of hit that head on. And then what that does is, if the other attorney gets up and says that, jury hopefully is thinking, yeah, Radner already told us that. He already addressed that. So it kind of disarms them a little bit.
Yeah. Always try to take the wind out of their sails. Jody Arrington gifted 5 Brother Counsel side memberships. Thank you for that. Here we go from Kristen Pino. I thought AJ using the words likely, possibly, could have, and others was brilliant.
Yep. There was one time I made a closing where I told the jury, you may think my client's guilty. You may be pretty sure my client's guilty. You may be willing to bet money that my client's guilty, but you don't know he's guilty. There is doubt that you can attach reason to, and here it is. And they came back and they told me, they said, first of all, we didn't like your closing. We didn't think you did a good job. I always ask them. And they said, secondly, we thought he was guilty. We really did. But we couldn't prove that he was guilty. So we had to say not guilty. We don't feel good about the verdict. And I remember walking away thinking to myself, I didn't do a good job, but you literally just repeated my closing argument to me. Okay. Hey, as long
doesn't
as
matter.
My job is not to make the jury like me.
That's right. Exactly. Yeah. And I think that was the stress that AJ used this time on the reasonable doubt. The fact that there's reasonable doubt and what that means, which is very important. Leslie gives $20. Thank you very much for that. Katie Fisher, hi BC and BCC from UK. Would you represent Karen Reed if there is trial 3.0? In my opinion, there shouldn't be. Thank you for a great conversation.
I mean, yeah, the answer is, of course I would. I have no problem doing it, but she's got exceptionally good lawyers. She does not need us.
That's right.
If there's a third trial and Jackson reaches out to us and says, hey, we need your help, I'd be happy to help. It's not going to happen.
All right. Jules, $2. Thanks both of you listening while I'm doing my paper. All right. Nikki says, like when Brennan implied Karen drove by and saw John before she went to John McCabe's in the morning. There was zero evidence of that. He just dropped that in there. That doesn't help his credibility.
Right. Correct. Nikki's 100% right on this. All he did was make conclusory statements and didn't point to the evidence. And that does not help you. When Jackson gets up and it's evidence, and then Hank gets up and just makes a bunch of conclusory statements. She drove a 6,000-pound vehicle directly at John and left him there to die. Yeah, except she didn't, because there was no collision. Don't you remember the testimony from yesterday where it was established that there was no collision? Should we talk about the x-rays that you didn't show your expert?
We're getting to that next, but I just want to get through some of this. Josh says the defense asked for the OWI charge. Okay, that's what we just found out now.
So again, that could make sense because then it gives the jury something to convict on if they are just desperate to convict her on something that really doesn't affect her life. It's okay. So right now she's facing life in prison, so she is on probation for a year. Big deal.
Well, I mean, Judge Cannoni is going to decide the sentence, so she may throw her away.
She'd have to be within the realm of reasonableness. You can't give and look, I don't know how she sentences drunk drivers in her courts. I can tell you that in the courts that I've handled drunk drivings in, there are only 2 judges locally who are known for putting every single drunk driving conviction in jail. Everybody else does probation.
Unless it's like a repeat offense, right?
If it's a repeat offense, then it's not just a drunk driving. I'm talking about a first offense drunk driving. And I can tell you, even most second and third offenses are ultimately just get probation, which I don't agree with, but they do. Except for 2 judges local.
Nikki, again, member for 11 months, by the way. Thank you, Nikki. Commonwealth can't object to lesser included if the defense wants. Solomon.
Okay. No. So pull that count back up again, will you? Okay.
Sure. Commonwealth can't object to lesser included if the defense wants the lesser included in.
Right. Okay. So that's generally the way it works in any case. Either side can request a lesser included, and so long as there's evidence of it, it's allowed to be included. However, the other side is allowed to object, and then ultimately the judge will rule. And in this case, it's impossible not to give that instruction if it's requested, because one of the charges is literally that she killed him by drunk driving into it.
Right.
So anybody would at that point would be allowed to ask for a drunk driving instruction.
Yeah.
Now,
I was just surprised.
You can also object. That doesn't mean the judge is going to agree with your objection. Like if you would ask for a lesser included of impeding traffic, or of filing a late tax return, well, then the other side's going to object, and it's going to be, obviously it's not going to be read to the jury because there's no evidence of such a lesser included, and it wouldn't be considered.
I was just surprised that the defense requested it. That's all. Lori Live 360 for the win. Last year, Judge Canoni said it had to be unanimous across the board. That was a lot of discussion about her comments there. John.
Meaning, one second, meaning that if you don't have a verdict for all of the charges, I don't want your verdict on anything?
Right, that was the implication.
That's nuts. Okay.
John,
I don't know. If that's what you said, that's crazy.
AJ Crush, thoughts on Hank Brennan's ridiculous boulder analogy? Okay, so this is where, remember, you made a comment about this, Solomon, on his opening, where he said, we are not going to prove that Karen Reed intended to hit John O'Keefe and kill him. All what we're intending to prove is the following, which is she intended to do a act which has a high likelihood, I forgot the exact language, would high likelihood of resulting in serious injury or death. So he said, let me give you an example. The example for that would be if, let's say, somebody drops a boulder in the middle of a busy highway and he's just doing it for kicks. He doesn't mean he doesn't want to kill anybody. He's just someone having some fun. But he intends on that act. He intended on throwing the boulder into the highway. And there's a very high likelihood that someone's going to get very seriously injured or killed. And that's what we're saying Karen Reed did. She intentionally did an act of throwing her car into reverse and gunning it to 24 miles per hour at least. And it has a high likelihood when you act that way to kill someone or injure someone. Now, what do you think about that analogy? And also, if you think it applies in this case.
Does it apply in this case? Yes. Has it been proven in this case? No. It's a good analogy. It's a good way of explaining the difference between second-degree murder and first-degree murder. This is also sometimes referred to as depraved heart murder, and it's called different things in different jurisdictions. But essentially, if you do an act intentionally, that the logical consequence of what you're doing is likely to cause either death or great bodily harm, then that is second-degree murder. For example, and that's a perfect example, is throwing a boulder off of the highway. If you stand on an overpass and throw a boulder off the highway, you're intentionally doing it. You're not intentionally killing somebody, right? Like imagine you're just doing it for fun. You want to hear the sound. You're showing off to your friends how strong you are. Hey, check it out. And you throw the boulder, and then, of course, it causes a crash, God forbid, and people die. Then the act that was done was an intentional act, and it was done with the knowledge that the logical consequence of what's going to happen next is death or great bodily harm of somebody. And as long as that's intended, that act is intended, that the logical consequence is that somebody's going to die or get injured, seriously injured, then that's second-degree murder. It's depraved heart murder. It's like firing into a crowd, which was the law school example that was always given to us, or standing outside of a stadium and shooting an automatic gun into the air so that bullets just go flying up. They're all going to have to come crashing down. And although you're not intending technically to kill anybody, it's almost certainly going to happen. So that would be considered depraved heart murder, second-degree murder.
Yeah, I actually like that analogy also. I thought that was probably the best part of his closing arguments, where he just explained what second-degree murder is.
But then he didn't explain how it applies. Which was the real problem. He didn't he barely focused on any evidence at all. And the real problem is the gaping holes that were created by the defense in the closing hours of the trial. Hank didn't even address. He didn't call a rebuttal expert because he couldn't. And he didn't even address it. There was no collision. That fact, in my opinion, was proven beyond a reasonable doubt. But it doesn't have to be. All the defense has to do is establish that there is a reasonable doubt as to whether a collision happened. And there is absolutely a question as to whether the collision happened. And if it didn't happen, there's no case at all.
Well, maybe if you're just plain DUI.
Maybe. But again, look, another real problem there is, what was her BAC when she was driving? What was it? When she got home, did she drink more?
Right. That's the argument that they kind of made. Okay, so let's move on with some of these comments. Florida fan, thoughts as to whether the feds will continue on investigation into the McAlberts.
I certainly hope so. I really, really hope so. It's interesting. I had a case one time. This case really breaks my heart. It really hurts to talk about this one. It was in 2013. I had a client who was innocent, 100% innocent. I've had a number of completely innocent clients. There's one, in my opinion, who was convicted of the clients that I'm positive were innocent, that I went to trial and lost. Generally, when I had a client who I believed with all my heart was innocent, either we went to trial and won, or we went to trial and got a mistrial and then had the case dismissed, or got the case dismissed early on. But this one particular case, my client was framed by dirty cops. There's no question about it. And while the case was going on, I got contacted by the FBI. They wanted to see my file. And I went to the federal building and met with the agents, showed them my file. And they looked at everything. And they were tracking my case very, very closely. And this case just is so devastating for so many reasons. The judge made some horrible rulings, which put us in a very, very bad spot. The jury was hung after 3 days, and the judge literally injected himself into the jury deliberations. And there were all kinds of improper things that happened during this trial. And ultimately, after 3 days of deliberation and the judge injecting himself and one juror getting replaced after 3 days, they ultimately did convict my guy, and he ran away. He ran away to a non-extradition country. He still calls me occasionally. But when I reached out to the FBI afterwards, they kind of said to me, "What do you want me to do? There's a jury conviction now." So it was, I'll tell you just a little bit more about this. This was where the main cop in the case produced some evidence that supposedly proved my client was guilty. The FBI sent me evidence that cop created that evidence. It was the wildest thing I'd ever been a part of, because I reached out to them afterwards and they said, we can't go after him now. They ended up arresting a whole bunch of other cops who were basically this guy's partners, but they did not arrest him. And this still angers me to this day that this happened.
Yeah, I know that case. Actually, I know that case well. Kristen from Manhattan, hit the like and subscribe to Brother Counsel. Let's bring Martin to 40,000. Thank you so much, Kristen.
Do it.
Let's do
at least
40,000,
50,000.
Yeah, I mean, we're just, that's just the next level before we move on to the next goal. But I appreciate Kristen. She's been a very big supporter of the channel, so we appreciate everything from Kristen. Thank you so much. Let's move on. We've got Sean Broadwick. I don't think they can hang just on OUI. They would hang on the entirety of count 2.
No, that's not how that works. If you pull up the verdict, you can pull it up. There's a checkbox next to that lesser included. What happens is there's the charge, and then under that charge, there's not that, but the lesser included. And there could be 3 or 4 or 5 lesser included, depending on what the case is. Like if somebody's being charged with murder and there's a lesser included of reckless discharge of a firearm, then that will be included in as a lesser included if somebody requests it. And my review of the verdict form is that they could find her guilty just of drunk driving. If you pull it up, we could take a look together. But that
okay,
was
my
review
mind.
of it.
All right, let me pull it up. Give me a second. Okay, give me 1 second here. Here it is. Let me just blow it up so you can all see it. This is the verdict form. So you see murder in second degree is the first charge. Guilty or not guilty. Then we have the manslaughter while operating under a motor vehicle under the influence of while operating a motor vehicle under the influence of liquor. And then we have these first 2. Then we have lesser included involuntary manslaughter.
Okay, go back up for a second. So, verdicts. Okay, so this is very important to look at. So in the above entitled case, we, the jury, say that the defendant is not guilty of the offense charged. If they click not guilty, they check that, then they move on to the next charge. They skip questions 2, 3, 4, and the rest of them. They can check box or any lesser included offense, right? They can go to number 2. guilty of offense as charged. That means that she's guilty of manslaughter while operating a motor vehicle under the influence of liquor. And then they have to check either one or both of these that apply as the basis for that conviction. Okay, so that's what those two would be. Number 3, and again, this is if the jury does not find number 1 or number 2, then they leave both of those blank. Now they go to number 3, guilty of lesser included offense, involuntary manslaughter. If they find her guilty of that, then they would only check box number 3. Or they can continue on. And number 4 would be guilty of lesser included offense, motor vehicle homicide, right? Felony, OUI, liquor, and negligence. And again, they would have to check one of those 2. They could, let's say, find her guilty of 3 and 4 and nothing else. Okay, number 5 is guilty of lesser included offense, drunk driving, which is what this is. So they could find her guilty of, let's say, just 5 and nothing else. Now, if they put a check next to box number 5, they're going to have to put a check next to one of those other 2 boxes too, at least one of those. If they just leave it blank, then the judge is going to send it back and say, this is not.
Well, so I think here's the question. The question is, let's say they find her not guilty of 1, 2, 3, 4, and then 5, they're hung on. So they can't click here, not guilty, because that means, or any of the lesser included offenses also. They're not going to hit guilty here because they think she's not guilty. They're not going to hit guilty here, 3 or 4. So now they're going to come to 5 and say, well, we're hung on this. So they're just going to leave this all blank, I would think, and then sign. That would mean that they hung.
Yeah, this is a problem. This is not a proper verdict form. Because if they all say that she didn't kill anybody, then they should be allowed to say not guilty of murder too.
Well, this is not murder too. This is manslaughter. Yeah.
Yeah. This is not a proper verdict form. Unless there's some strange law in Massachusetts that allows this.
Yeah, exactly.
Right. I mean, the way it's written, that's.
If they leave this blank or if they hang on any of the lesser included, you'll never know what they're hung on.
Did the defense argue this?
Yes. Yeah. Yannetti did ask that there should be a not guilty for each individual one. So not guilty for the top one, number 1, just not guilty of the offense of the manslaughter by operating under the vehicle, whatever. And then 3 would be
each
guilty.
One. Yeah. For each one, 2, 3, 4, and 5, there should be a not guilty under each one of those. Yeah. This is not a proper verdict form. Not at all. This is ridiculous, frankly. Because what you're telling the jury now is if you hang on 5, then it's a hung jury on that entire charge. That makes no sense. This cannot be allowed. There's no way that this is a proper verdict form.
Exactly. See, that's the problem. Okay. I'm glad we walked through them and pointed out that problem. So that actually takes us to the next question by Fast Finance with Jennifer. Thoughts on the verdict slip? Well, you just heard it. Nikki, can Karen call FBI investigators as witnesses in any civil rights or civil cases she has?
Good question, Nikki. Another very good question by Nikki. The answer is you can try. The FBI does not have to comply with subpoenas. All you can do is ask, and they decide whether they will say yes or no. So you would ask for a witness, and they would probably give you one, but there's a good chance they wouldn't. Not if there's an ongoing investigation or if they just don't want to tell you about their investigation. I've had cases where I've had to subpoena things from the FBI, and you can't subpoena it. All you can do is ask for it, and then they decide what to give you.
TUI requests, right? Is that part of the TUI requests?
Exactly.
Jules, if they can't convict for OUI, can they not convict the other charges because they are elements of the other crimes? Also, happy Father's Day.
If they can't convict for OUI, you can't convict for elements. You can only convict of crimes. That's why that verdict form is such a problem.
So essentially, yes, they do need to find that she's OUI in order to get any of the other ones, right?
Correct.
So yeah, I mean, I guess the answer to that is yeah.
There has to be a not guilty under every one of those boxes, and the fact that there aren't is just ludicrous.
The virtual juror says Massachusetts first OUI sentencing potentials license suspension up to 45 to 90 days, fines from 500 to 5,000, and jail time up to 2.5 years. That's for first OUI. Solomon.
Okay. I don't know Massachusetts law. I don't know if that's correct. I would certainly hope that's not correct. But maybe it is.
And again,
Maybe
Chris from Manhattan says the OUI charge brings a max of 2.5 years. If Judge Cannone sentences Karen Reed to the max, what can the defense do to appeal the unreasonableness? Tom Kukanowski, master criminal attorney, has litigated in front of Judge Cannone, said she'd give her the max.
She probably would, because she'd probably feel just as defeated as the prosecution, because at times she's acted like an arm of the prosecution. She should be ashamed of herself.
Kelly Whiteside, amazing thing about this trial is Karen had the dream team of the whole U.S. and beyond of lawyers helping, as I know her team was watching all of you.
I don't know about that. When you're in trial, you don't have time to watch videos. You just don't. All you have time to do is to prepare for the next day of trial.
That's what I've been saying this entire time, although I something tells me that in this case, because they have so many people helping them, and there's so many, I don't know, law clerks, other lawyers that are helping behind the scenes that we've never even heard of, it could be that they've got some people that are watching some of the us lawyers talk about it. And if we bring up a good point, then they may bring it to their attention.
It could be that they have people doing it, but like Jackson's not watching.
Oh, Jackson himself is not doing it.
All he's doing is reviewing evidence for the next day's trial.
Yeah, no question about it.
And the defense was so sharp. The defense had everything. They had everything at their fingertips. There was one mistake they made about one of the slides of one of the experts. I remember them arguing about, right before a lunch break, they argued to the judge about one of the slides. Maybe you remember this. And then afterwards, the judge said, no, that's not what the slide said. So I'm not going to give whatever instruction you're asking for. But generally,
that was, I know exactly what you're talking about. You're talking about when they were talking about Welcher's slide, which Welcher had his opinion on a specific slide. And I mean, this is what they argued. They argued that their experts, Rensselaer, should be able to show his PowerPoint and included in the PowerPoint have his opinion there. So they were arguing that, and Brennan objected and said it's just hearsay. You know, he can testify to that, but he can't put it on the PowerPoint. And they said, well, you allowed Welcher to do that. And then that's where they made a mistake, where Judge Cannone came back and said, no, actually, those slides did not come into evidence. So that's where they made a mistake. T. Shaw, I'm way behind, but wouldn't this all be overturned on the dog DNA evidence coming in without Hank calling the tech at all to get it in? So remember that has to do with our, sorry?
What's this referring to? That one expert who threw out something about dog DNA evidence?
So
this I think one of the things that Alessia was asking for a mistrial on, right?
Exactly. Yeah, that's what we spoke about last week about that. So is there anything that's going to be overturned about that dog DNA evidence coming in? Could be.
I don't think so, because I think the jury's going to find her not guilty.
Okay.
So there's going to be no appeal.
Auditory storytelling. My issue is they can't acquit her of the other offenses above OUI.
Correct. That's the problem. That's exactly the problem.
Exactly.
That's exactly they cannot find her not guilty of all those other lesser includeds. And that's why that verdict form is flat out improper. It's an improper verdict form. It's inconceivable that verdict form is allowed. Can't be.
Agreed. We just went through why. I mean, it's just wrong. Judge said if they could find case law to support the verdict slip change to what they want, she'd think about it. Is there case law?
There's got to be. There's got to be. My guess is that they're going to find the case law over the weekend to bring it back on Monday, or as they call it in Boston, case law.
Kim Neighbor wants to see the sandwich exchange. Okay, so I actually was not going to play the sandwich exchange, but if we have a specific request for it, I'm going to try to find it. I was going to play you something else, but in the meantime, while I'm looking for it, Solomon, why don't you tell everybody your opinion about this whole Welcher X-rays situation? Welcher said that there was no X-rays. There were X-rays. It was shown to Welcher. Jackson argued it. Tell us your thoughts about the X-ray and Welcher.
There's only one of two options. Option A is the expert lied. Option B is the prosecution didn't give him the X-rays. Either way, that was a massive, massive point. Somebody told me early on in my career that if you can prove that the other side is lying and intentionally trying to deceive the jury, you've won the case. And that testimony about the X-rays did that. it accomplished that without a question, because the prosecution's expert got up and said there were no X-rays, and then the defense expert is showing everybody the X-rays. It was a dynamite moment.
Yeah, maybe that's probably why he didn't call Welcher in rebuttal, because if this would have come out, well, Dr. Welcher, did you see these X-rays before or not? Did you lie that you saw them, or is it just that Hank Brennan never gave you these X-rays? Which one is it?
So, and I'll tell you something else. If the defense wanted, and this is kind of what I would call part of the ground and pound game, which is once you got them, just keep throwing punches. As a defense attorney, you can recall Welcher yourself. And how strong would it be if right after all that, the defense would have called Welcher and said, you testified that there were no X-rays, correct? Correct. I'm handing you exhibit number whatever. What is that? An X-ray. This is the first time you're seeing that, isn't it? Who did you speak to on the prosecutor's team? Did you speak to Mr. Brennan? Who did you speak to over here who told you there were no X-rays? Or did you see the X-rays and lie about it? Which one is it? There's no way to rehabilitate that testimony. There just isn't.
Exactly.
That's it. Done. And then you could say, okay, now we're done. Now we rest. What's Hank Brennan going to do? Get up and say, well, let's talk about fragments of taillight again.
Sharon Reeves, in the state of Massachusetts, the first and only duty of the prosecution is to seek the truth, not to simply convict. Massachusetts versus Kia. Yes, in fact, I put that. Yeah, I put that up in one of my slides that I did a kind of like a mock closing, and that was the first slide. Anyway, so
that's every prosecutor, by the way. Every prosecutor has that duty. Sadly, some of them don't honor that duty. A lot do. But it's really, really hard to look at this case and think that anybody with any intelligence at all, after reviewing the evidence, could believe that Karen Reed is guilty.
All right, well, Solomon, now we have to, by popular demand, I have to play you the ham sandwich clip and get your reaction, okay? So here we go.
Okay.
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took their ride. If I wanted to appear independent, then I would have taken an Uber.
You had a conversation about that you were thinking about taking an Uber.
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
Did you have any bias for any of you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people. And so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
You had a ham sandwich. Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
Oh, gosh.
This is sad. This is really sad. This is all Hank's got. It's truly pathetic. This is a truly pathetic line of questioning. Now, as the defense attorney here, what I would have done is I would have gotten up and said, the prosecution just asked you lots of questions about the ham sandwich. Could you possibly be bought for a ham sandwich? Would a ham sandwich give you the encouragement that you need to commit perjury? No. And then I would have said this: we didn't give you $340,000, did we? Nothing further.
Boy.
Go ahead, Hank. Keep trying to convince the jury that our expert is lying because we gave him a ham sandwich when you gave yours more than almost $500,000.
Oh yeah, that was
gracious. I mean, that was a truly pathetic line of questioning. But again, one of the most pathetic blow up in your face lines of questioning I've ever seen in any trial ever was what Hank tried to do to, I'm probably going to butcher her name. Is it La Posada?
Oh, La Posada.
Oh my God.
Yeah, okay, so hold on, Solomon. Let me pull it up.
Unbelievable.
So hold on.
She was a dream expert. She's the expert everybody wants in their case. She's the expert everybody envisions hiring in their case. She was
Solomon,
awesome.
let me pull it up right now. Here it is right now. So take a look. Take a listen. This is just one snippet.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Is that what you're talking about?
There were a whole bunch of those. It wasn't just that one. It was every time he thought he had an attack line of questioning, it blew up in his face. Like the whole that fire where she sent her investigator out to the field and supposedly didn't do her job and got, it just blew up in the prosecution's face fabulously. It was incredible.
Mm-hmm. Let me just play you a few more to get your because I'm telling you, I have never laughed so hard watching a witness testify like I did with Dr. Rentschler, because it was just like, let me just get one more for you here, at least one more. Take a listen.
And we didn't get any contact. So I have personal experience just with this case alone.
We'll get to the contact. When you look at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that. And I've never seen a case where you get these types of abrasions.
I didn't ask you that. Is that funny?
It's not funny.
Okay.
I was thinking, yeah, it actually is funny.
So this is Hank's attempt at doing what Jackson did with the nefarious. Why did you say nefarious? I didn't say nefarious. And there was another witness with malicious. I didn't say malicious. Why'd you say malicious? This was Hank's attempt at doing that. It didn't work. Like his entire cross-examination of all the defense experts, it just blew up in his face. It was terrible. You have days like this as a lawyer where everything you think you got just blows up in your face. Those days are not fun. They happen to everybody. And unfortunately, it happened to Hank with the entire world watching. I don't think this case is helping his career at all, sadly.
And take a look at this last interaction with him and Dr. Rentschler.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his pain test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision?
He did not state that. That's correct.
So when you've made your criticisms that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement on it that he was trying to reenact the actual collision.
When I did that, there's one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion.
So,
yeah, again, just blew up in his face. You got to ask Hank, what's your point? I tell this to people all the time. I tell this to my clients and I tell this to lawyers. Every single time you're cross-examining a witness, you have to have a specific point you're trying to get. And you can't lose sight of that. You can't get caught in the weeds. Just because you have an attack line of questioning for something that was said, you got to stay focused on your mission. What is your goal with this particular witness? What is your goal with this line of questioning? If his goal was to destroy his own witness, then Hank did a nice job. But that line of questioning basically just told the jury that they should disregard his own expert's testimony because it didn't reenact anything.
Exactly.
It's like, and I'm sure when Hank rewatches this, or it could be he picked up on it 30 seconds later, he must have been kicking himself saying, oh, good Lord, what did I do? And yeah, but you destroyed your own case.
Yep. That's exactly
we'll see if Judge Cannoni bails you out with this insane verdict form, which doesn't allow the jury to find her not guilty of everything.
Creed, you think a federal court might punt this on habeas? The DA was allowed to impeach using a federal agency breaking a state order with their federal contractor, ARCA, without the defense being able to rebut it.
Creed, good question. You're mixing up a couple of concepts here. Just to kind of give everybody an idea of what a habeas appeal is. If somebody's convicted of a crime and they go through all of the appeals that are available in the state system, and they're still under state control, meaning they're still in prison, generally is what the rule is, or if probation is so restrictive that it puts a restriction on their life, then they're allowed to go to federal court and file what's called a habeas appeal or a habeas petition, where they ask the court to say that their constitutional rights are being violated and there has to be a constitutional right that's implicated. That's from 30,000 feet what a habeas appeal is. Whether there's a federal agency involved doesn't affect the habeas appeal. There doesn't, and I know that this is confusing to a lot of people because when you hear federal court, you think it's a federal agency. That's not necessarily the case. You don't need a federal agency in order to file a habeas appeal. So I don't really understand that question as asked, but I hope I was able to clarify things a little bit.
Cat Williams says it's a proper verdict form in Massachusetts. Should it be changed? Yes, but it's proper. Apparently,
That's insane if that's true. Look, I've learned a lot about Massachusetts. Okay, if that's true, that is completely ludicrous. And frankly, if that's the case, I got to question why the defense insisted on putting in the drunk driving charge, because now it makes no sense at all. Now you're not giving them the chance to find you're not guilty of everything.
Well, they can just find her. They can still find her guilty on OUI. But the only issue is going to be is if they hang on one of the lesser includeds, and they're not going to know how to fill out this verdict form.
Right. Yeah. That's I don't now I completely disagree with the defense approach of asking for that lesser included. It doesn't make sense to me if that verdict form is proper. Now, obviously, they were asking for it not to be allowed because, and I don't know who just put that comment there. I really hope that she's wrong because that verdict form makes no sense. To me, it smells of a violation of due process. It's not even a fair trial. You're not allowing the jury to come back with not guilty on the other lesser includeds.
Yep. That
makes no sense to me.
Exactly. Sandy B, what about they didn't charge her with OUI till the last day of second trial? They didn't add that. It's innately part of the case.
Right.
So
it's part of the case. It's part of the case. It's one of the elements of the higher charges.
Mr. Meaduk, a meal's last bite lingers for longest. Hence Rentschler, the trial's last bite.
Right. And that's why you got to wonder why the prosecution didn't call any rebuttal witnesses. And the answer is they didn't have any. It wasn't going to happen.
Allison Currington, Brother Solomon, recognize your voice on week 2 from my listening to arguments online. You fight hard and believe in the fourth.
Which case are you talking about? Can you post another comment, please? Because I'm really curious about that. I get comments like this all the time, emails, text messages, calls. Clients tell me that they've heard or saw me online. I haven't posted anything, which is why I know you and I have kind of been kicking around the idea of maybe starting my own channel where I post my own stuff, because apparently I've got a lot of things out there that other people are posting, and I don't know what people are referring to. So, Allison, if you could maybe reply to your own comment saying what case that was, I'm really curious.
That's going to be hard to find in the chat because we have a very active chat, but you can send an email to brothercounsel99@gmail.com. All right. Here is Debbie Gross. This verdict form is precisely why the jury hung on the first case. Afterwards, some jurors came out and said they thought they had to be unanimous on all 3 counts because the form was not clear. Well, now we're seeing why
they do, based on the way it's written and based on the way it was argued and based on Canonia's ruling. If you find case law, let me know. Yeah.
Earbuds in the kitchen. How do they document a hang on OUI while making not guilty on the higher ones using that form? That's exactly the issue. That's exactly the issue, Earbuds. Wouldn't they be leaving them all blank? Exactly. That's exactly the problem.
If they're unanimous that there was no manslaughter, but not unanimous on whether she drove drunk, then they have to leave all those lines blank. Which is
I mean, I think, by the way,
and again, if this is allowed in Massachusetts, I would argue that this is violative of due process.
I mean, Solomon,
because it completely takes away her right to a fair trial.
And I think, again, and we don't know if anybody from the defense team is watching, but if they are, I think that this is what should be brought up on Monday. Ask Judge Canoni, Judge, what would happen if they find her not guilty on 1 through 4 and 5 they're hung on? How would they indicate that to the court?
Right.
I think they should bring it up and just ask her, and then then it's a clear record that there's a problem.
Right.
Okay.
It's ridiculous that if they're only hung on 5 but unanimous on the top 4, that they can't get a verdict on the top 4. That's just ridiculous. It's inconceivable to me that that's correct. It's just I really hope it's not right.
Well, it's definitely not right what's happening in the case that they have this verdict form. I mean, that's not right, because
Yeah, well,
all right, here we go.
if Massachusetts allows it, then they allow it, but it just wouldn't make sense to me.
Imagine AJ closing. Mr. Brennan asked hard-hitting questions like, "Did you laugh about a joke with eating a ham sandwich?" to our physics experts. Okay.
So sometimes a question like that after a long, intense trial is exactly what everybody needs to just, smile and laugh.
Can you briefly compare the witnesses for the prosecution first versus the defense? I mean, I think we spoke a lot about this. I mean, we can't, it's getting late in the show, but yeah, the defense's experts were obviously a lot better than the Commonwealth's expert witnesses, and there's a lot to unpack with that question. So I'm sorry, let's move on.
The defense experts were exceptionally good, and the prosecution's experts, the majority of them, were just not good. They just weren't good.
Yep.
They
Rush
didn't
to
prove
judgment.
anything.
Great idea for defense to call Dr. Blue Paint, but they thought he was being called in rebuttal. Hank didn't say they weren't going to do a rebuttal until after the defense rested. And remember that he was posturing the entire time like he's going to be calling Welcher. In fact, he wanted more time to be able to test and to do more testing based on ARCUS testing. And there's like spirited argument about this. And then as soon as the defense rested, yeah, we're not calling any rebuttal witnesses. It's like,
That's giving up. Just
yeah,
is.
here's John Fearborn. I survived the station nightclub fire. It was chaos for a month. 96 people died in the club, 4 in the hospital.
Wow.
So it sounds like John was actually there. That's the nightclub fire that Dr. La Posada was the chief medical examiner for.
Yeah, that's crazy.
Mama Shell, would it hurt Hank Brennan's last cases if he discredits La Posada since he has used her in the past cases and might have won? Seems he was being careful. So there was some sort of suggestions or argument that Hank Brennan actually either used Dr. La Posada to review a case or spoke to her about testifying one of his cases, but it's not clear, or was not clear to me, whether he actually utilized her as an expert in a case that he took to trial, or if she's on a witness list. I'm not sure anything more about that.
I don't know. I think that's there's a story that I heard from a partner of mine who said that he had a case. It was a pharmaceutical case, and they had their expert on, and the attorney started cross-examining the expert and was going on 3 days of cross-examination. And this expert waited for the right moment and waited and waited and waited. And after 3 days of this lawyer attacking this expert as not knowing what he's talking about, the expert said, "But Mr. So-and-so, I testify for your firm all the time." And it just, you talk about flat-footed. Associates were fired because they didn't warn this guy about that. A sad situation, but yeah, but it was a big firm. They use this expert all the time. He's a renowned expert. And then there they are, attacking his own credibility. What do you think the next lawyer that attacks that expert against that law firm, they're going to use that transcript?
Virtual juror, Judge Canoni said she was upheld by the SJC read the verdict slip. And again, I think this comes back to what Alan Jackson argued in the first case, is that I don't care if that's how they do it here. I want it to be done the right way. And this is obviously wrong. It's obviously wrong. It's so clear.
This has to be taken up. If the state of Massachusetts won't deal with this, then they have to go federal, because that verdict slip cannot possibly pass constitutional muster. It's inconceivable to me that verdict slip is not violative of due process.
Yeah, I think you're right. JCS Monroe, Hank used the iPhone temp issue wrong. The phone temperature goes down when the phone stops being used. The processor slows and it cools. We all know how hot it gets under high load. Why not argue it? The battery temperature phone, because I don't think he had to get so much into the weeds with that, Alan Jackson. I think that as long as he showed how it could be that phone was in the garage and that's how it was slowly losing temperature, that's, what more does he need?
Yeah, I think once it was pretty much established as a matter of fact that there was no collision, the case ended.
Yeah, right. Jennifer Clark, happy Father's Day to 2 wonderful brothers. Love the suggested line of questioning. Is a ham sandwich enough to make you lean into a theory to prove a client's case? Thank you both. Remember that Welcher leaned into the car? Oh gosh,
Mm-hmm.
It was just a disaster. Vincent McCormick, and remember, I've been telling everybody from the first trial, if the Commonwealth can actually get a real expert and recreate this accident and show how it's possible, then all bets are off. But until they do that, ARCA is going to win the day every single time. And they miserably failed this time, trying to get some sort of expert. Welcher came up with the blue paint test. Give me a break.
Right. Well, to take it a step further, the prosecution has to prove what happened. They can't just prove a possibility of what happened. The defense proved multiple possibilities of what happened, none of which include a murder or a killing by Karen Reed. The prosecution didn't even really propose a possibility of how Karen Reed killed him, because after all the defense experts completely destroyed the idea that she hit him with her car, nothing was done on rebuttal. Nothing was done to hurt the experts during their testimony by the prosecution, and nothing was done on rebuttal. So to me, it looked like Hank threw in the towel. It really did.
Yeah, I mean, after those experts, it was, and then not calling Welcher. I mean, it was basically waving the white flag. Vincent McCormick, I love Dr. LaPosada reporting that she'd consult with neuropathologists when Brennan kept asking why she didn't consult with a neurosurgeon or neurologist about brain injury findings. So this is a line of questioning that Hank Brennan also, this was literally a clinic of how not to cross-examine witnesses, because I've said, if a witness testifies and it's going to hurt your case and you don't have any way to help your case, don't get up and ask questions. Okay, so that witness is going to be bad for your case. But if you get up there and try to score all these points and all you do is get the witness to say 500 times that the car didn't hit John O'Keefe, you're not helping your cause. Just shut up and sit down. Bad is better than terrible. So,
right. Do you remember the defense cross-examination of John O'Keefe's mother?
Of course.
What was it in its entirety?
Yeah, I'm sorry for your loss.
That's it.
Right.
No reason for anything else. No reason to show clips of Karen Reed, of talking, of the relationship. No, there's no reason. You got to stay laser focused. What are you trying to get out of this witness? If the answer is nothing, don't ask anything. Just sit down.
Yeah, and I think the truth is, I think that what Brennan mistake here is that I think he got a little bit ahead of himself, because he scored a little bit with Dr. Russell. And I think he felt emboldened by the way he was able to cross-examine Dr. Russell about, you didn't know about the angle of the car, you didn't know this, you didn't know the speed, you didn't know that, and you didn't know the other thing. And he was actually able to get somewhere. And Dr. Russell didn't deal with Brennan the way that LaPosada and Rentschler did. So I think that he thought he'd be able to deal with them the same way he did with Russell, the same way he got with Russell. And instead, all he got was LaPosada and Rentschler kept saying, well, yeah, I didn't consider it because there was no collision. The car didn't hit him. So all he got them to say is multiple times state their opinion again in a very clear way that they don't believe that the car hit him. Okay, moving on. Here we go. Another. Okay, I don't know if I caught this before. First offense, OUI, Massachusetts, MGL Chapter 90, Section 24E allows for dismissal of charges after completion of terms of probation. Okay, so there is that possibility, but we'll see what Judge Canoni does if that comes back as McNair or Mick. Something hit the concrete. Oh, Allison Currington, Solomon. This is the case. This is the case that she saw you on or heard you on. McNair or Mick something kissed the concrete. Remember that case?
Wow, I do. Yes, that's where I'm representing a prison inmate who was told by a prison guard that he will kiss the concrete if he's rude to him or something along those lines. And he kissed the concrete. He was grabbed and pretty much slammed against the bars and then against the concrete while he was handcuffed on video.
Wow.
Yeah,
McNair. Scooters 54. What do you think the likelihood of a pardon from the governor is in the unlikely event of a conviction?
Extremely, extremely, extremely slim. Super extremely slim. I just don't see it happening.
Kelly Whiteside, my favorite part of your channel is when you are trying to go over the clips and try not to laugh, but it is so outrageous that we all end up laughing out loud.
Yeah,
I'm telling you, I saw I heard the second half of Rentschler's testimony or cross-examination on the road. And people must have thought I was crazy because I was just laughing, on the road while I'm driving down, the 76, whatever. It was just hilarious. WIG, happy Father's Day. I litigate plaintiffs' med mal cases in New Jersey. Scortibello's testimony would sink this case if it was a civil action. Despite lower burden of proof, I would have rejected on intake.
Right. And just to explain to everybody what that means that this would not even prove the case by preponderance of the evidence, is what this attorney is saying. Yep. Forget beyond reasonable doubt. You can't even prove by preponderance of the evidence. Preponderance of the evidence is a much lower standard. It's known as the 51% standard, because all you have to do is establish that something is more likely than not in a civil case. 51% is more likely than 49%. That's why it's called the 51% standard. Beyond a reasonable doubt is more like 99%. So what he's telling us is that if this were a civil case, he wouldn't even try it. He would have rejected it when he was conducting the intake. And I agree completely.
Yeah. And I've said this also because she has a civil case right now filed against her, which is the thing that she's going to be facing after she either gets acquitted or a hung jury here, that she's going to be facing the civil case.
I'll tell you right now, I think the reason that the civil case is filed, and I've seen this used as it's kind of a way to cheat. That said, there's nothing wrong with it. But when you sue for a civil case for something like this, if she's found guilty, then it's res judicata. It's just a question of damages at that point. You don't have to prove anything because the proof is already there. If the jury finds her guilty of let's say, manslaughter or murder, then at that point, you could just use that, go to the civil case and say, hey, she was already found guilty of this. Let's go to trial on damages. If they have to prove the case from from go, I think it's going to be much, much harder for them. And I don't know if they're going to really want to proceed at that point.
Yeah. And like I've been saying,
big time uphill battle.
Like I've been saying with the Karen Reed civil rights civil case, I've been saying, you give me ARCA, I'll defend her all day long in the civil case. I'd be happy to defend, when I have those experts.
Right.
Even when the burden is that much lower.
One more thing to keep in mind when there's a civil case and a criminal case pending at the same time is that everybody knows that you're not allowed to use a defendant's silence against them in a criminal case. You are allowed to use their silence against them in a civil case. So in the event that, let's say, the civil case is going at the same time as the criminal case, and you take her deposition and she just pleads the fifth, well, that's not going to come in the criminal case, but in the civil case it can. And as long as the criminal case is pending, her civil lawyers are going to tell her you can't testify or you got to plead the fifth. So that's why I said it's kind of cheating, but it's allowed. So if you know that there's a criminal case pending, you just take the deposition and they either answer questions, which you can then give to the prosecutor, and then they can use it in the criminal case, or she pleads the fifth, and then you can go to the jury in the civil case and say she pled the fifth. You can use that against her.
Judge Canodi's instructions not allowed, and this is again from Nikki. Judge Canodi's instructions not allowed to complete the verdict form until they're unanimous, letting Commonwealth retry the entire charge if hung on a lesser.
Right, Nikki, exactly. And that's what's so problematic about it. And that's why I think even if Massachusetts allows it, I think it's still unconstitutional. I think it violates the 14th Amendment due process.
This is a funny part of the closing argument. Kim R is pointing out, Hank Brennan was really stretching when he said Shannon Burgess was the hero for finding the SD card when no one else could. If that's all you got, it's not good. Now, this is when Shannon Burgess, right? We all know the issues of Shannon Burgess.
Oh, right.
That's with the CV issue. And then,
17 years going for a bachelor's degree.
Yeah. And Jackson didn't say that in the closing. That would have been nice if Jackson would have just kind of thrown that in. Let's talk about Shannon Burgess, who's still pursuing his bachelor's after 17 years. This is the guy that, remember on the TV, but Hank Brennan tried to say, well, he was the guy who found the SD card when everybody else didn't think that there's anything to find there. Wow, he is the hero of the case. I mean, no.
If La Posada is everything you want in an expert, Burgess is everything you fear in an expert. When you hire an expert and put them on the witness stand, you want it to look like La Posada. Your nightmare is that it's going to look like Burgess. That before a single substantive question is asked, you've already established that the guy's lying through his teeth and is not trustworthy.
Yep.
Just an absolute disaster.
And not only does he destroy his own testimony, but then he also throws some serious shade on the next expert who works for the same company. So, sorry, off topic. I'm a summer associate at a firm. This is from Kelly Kell, and was wondering what are signs that things are going well. Also think I convinced a partner that Karen Reed is not guilty in 5 minutes. LOL. Thanks. Well, really, all you have to do is what I do with a lot of people is just show them the picture of the arm and say, tell me what that's from.
Right. I told you that's good. That's like trying to convince a jury that the earth is flat. So Kelly Kell, that's a good question. I'm curious if it's a big firm or a small firm or a medium firm. Look, this is going to be very seriously a case-by-case analysis. It's going to depend what state and city you're in. It's going to depend on what law school you're in, what law firm you're a summer associate at. It depends on a lot of things, but just from 30,000 feet, the thing that you want to ask yourself is, can you see yourself working with these people for years and for a very, very long time? Because ultimately, especially at big firms, when you say summer associate, I'm picturing a big firm. Very often you will spend more time with your work colleagues than with your own family, certainly for the first few years that you're a lawyer. So now Martin and I both have never worked at a big firm. After COVID, I kind of worked at one law firm. I did work at a law firm for 13 months, but that's the extent of my employment history. I've always been on my own. Martin has always been on his own. He's never been an employee anywhere as a lawyer. So we can't really tell you much more about that. I can tell you about the associates that I've hired and what they've told me and what friends have told me, and just what I've learned from working in the law in general is the ultimate question is whether you can see yourself working in that kind of firm. Look around at the partners and ask yourself if you can really see yourself being that, because that's obviously what they're looking for, and that's most likely what you're going to be if you're going to make it in that firm. But again, there's a lot of specifics you would have to take into account. So good luck, Kelly Kell.
Let me just throw in a little bit of what I've experienced, because actually I know Salman, once I became a lawyer, I was working for my own firm, but I did work for a pretty high volume firm when I was a summer associate after my was it my first year or second year, and that was a tremendous amount of experience that I gained. But I will tell you this, and I know this is off topic, but important question. When you say what other things are going well, I think that when you do work, and I don't know what they're giving you to work. But when I came in, I wanted to learn as much as I could. So I wasn't just happy just doing what the assignments that they gave me. I would ask them, give me as much, as broad of assignments as possible. I want to touch everything. I want to answer discovery. I want to write case evaluations. I want to respond to motions. I want to attend depositions. I want to help you with trial prep. I want to do all this stuff so that I learn. And when they see that, obviously they like someone who's trying to learn it and not just do whatever project you're given well. But then you'll start getting some input on some of the work that you're doing. And if I respond to a brief, I'll see the final edit that's actually filed, and I'll take a look at it and see and compare with what I did. What did the lawyer add that I did not add? How did they beef this up? And then I'll go back to the lawyer and say, hey, can we just talk about this? I added this, you took this out. Let's talk about it. And then that's kind of how you see whether your work is good, if they're implementing your work. And also it just shows them that you're really interested in learning how to become a good lawyer. And they always like that. So that's just from some of my experience. Okay, let's move on and see if we can get back on a topic here. Creed, Hank Brennan, I don't need Proctor to prove my case. Well, I don't need a knife in my behind to do jumping jacks, but it being there is a problem. Also, is this the first ever impeachment of a ham sandwich?
Creed's hilarious. Yeah, some very good points there. I've never seen a sandwich be used as impeachment. I've seen money get used as impeachment. The last case that I tried, we were able to establish that the expert who was offering very questionable testimony was paid $40,000. And, certainly I think that went towards his credibility. But ham sandwiches generally, it's not enough to make somebody change their mind.
Yeah, and he's saying that I don't need Proctor to prove my case, because he's trying to distance himself from Proctor. Proctor touched everything in this case. It actually just reminded me, there was one time I had a case. I was again in a civil case, and I was trying it, and I was up against one of these big firms that they did a ton of discovery. They had all these documents, and my exhibits were like, this big. I had some medical records, I had some pictures, I had some of my exhibits, and I did my closing argument, and then the defense and their closing argument. What he did was, kind of for theater, he pulled up all of his exhibits and he slammed it on the table. He's like, are you really going to find for the plaintiff? Look, he's got these exhibits and I've got these exhibits. And in my rebuttal, what I did was I said, ladies and gentlemen, all those exhibits support my case. These are all supportive of the plaintiff's case. This is exactly why you should find for our case. But we ended up winning that case.
That's fun. Yeah. What I had a defense attorney one time introduce 6 bankers boxes of records and didn't even open them. Just introduced them and said, here you go. You feel free to peruse these. We wheeled them into the jury room before the jury was there. We literally wheeled them in, put them in the corner. And after the trial was over and the verdict was read, those 6 boxers were sitting in that corner untouched. That is not the way to show a jury your case.
Entry record. You can't recreate taillight being magically planted. The Great 99. What is next for Brother Counsel and our Brother Counsel community after this trial is over? That's the $1 million question. That's a great question. We have to see what's on top. I know we have Brian Koberger coming up, I think, at the end of July, but that's about another 6 weeks. So maybe we'll get involved in the pre-trial motion of, and maybe some motions in limine, other things that are being filed in the Brian Koberger case. So that might be something we'll take a look at. I know some people want me to cover Adelson. That's also coming up at the end of July, maybe beginning of August. But if anything else exciting is going on in between, I'll definitely take a look.
You should put up a poll. Let your community vote on that. Which case they want you to cover next. If they want more Q&A, if they want more, just more information about a lot of cases, or kind of like what you did with Karen Reed, just a ton of information about one case. That's something you should kind of put a poll up. Maybe on brothercounsel.com when that goes live.
Maybe they'll want me to cover one of your cases, Solomon.
Maybe.
Colin R. Very informative and interesting Thanks, guys. Content. Thanks, guys. Rush to judgment. So we have proof a prosecutor can both indict and impeach a ham sandwich. What greater comment to end the show on? So thank you all for joining us today. Thank you, Solomon. I'm going to pull you off of the screen just so I can say goodbye. Thank you again. Happy Father's Day.
Happy Father's Day, everybody. Thank you for having me. It's always nice to be here.
All right, so there you go. That's Brother Solomon. We'll see if we got started with Brother Solomon's channel. We've been talking about it, Solomon and I, but we'll see. He's a busy guy. Maybe we'll put something together. We'll see. But in the meantime, thank you all for joining us today. We had a great discussion, always a great discussion with Solomon. I think this verdict form is really a problem after we actually gone through it on the show. And now that we see what the real problems with this verdict form is, I think there's got to be a clear record of it. I think that coming in Monday morning, they should just simply ask Judge Cannoni, Judge Cannoni, what should the jury do if they find not guilty on 1 through 4 and they hang on 5? How should they let us know? And there you go. So I think that should be stressed on Monday morning as soon as they come into trial. But other than that, that was a great having Solomon. Thank you all for joining us today. Let's just pull up this one more comment here from Gina. Brian Walsh case. You have a big Massachusetts following. Okay, when is his case? I'll have to look up Brian Walsh. I think I did look it up, but I'm not sure if there was a. Oh, that's not Sandra Birchmore. No, I don't know if there's a Sandra Birchmore. You can't cover because it's in federal. But Brian Walsh, I'm not sure where that is. And I'm not sure when the trial is. But I'll take a look at it. So all the things that are on the coming up in Court TV and Long Crime Network, whatever everybody else is getting interested in, we'll definitely be covering over here. So that's going to be it for today. Thank you all for joining. We'll see you back here maybe tomorrow, Monday, when we have a verdict. Everybody have a great day. Happy Father's Day.